Thank you so very much for being with us. The Alex-Murdaugh saga continues. The convictions that found him guilty in the deaths of his wife Maggie and son Paul have now been overturned by the South Carolina Supreme Court. And in their decision, the Supreme Court cited former Colleton County Clerk of Court Becky Hill's comments to jurors. The defense says her statements like, quote, watch his body language, implied Murdaugh's guilt, preventing him from getting a fair trial with an impartial jury. It was clear during that previous hearing earlier this year that the justices were concerned about that issue.
We all can cherry pick some of these that are on the surface innocuous. Epic day, big day. And when viewed in isolation, they don't move the needle, arguably. But when those seemingly innocuous statements are considered in the aftermath of the originating statement, not to be confused and misled by the defense, those initial innocuous statements take on a very nefarious message.
Well, shortly after today's ruling, the State Attorney General Alan Wilson and the chief prosecutor in the case, Creighton Waters, holding a news conference. They say they are disappointed with the ruling, but plan to move ahead with a new trial.
You don't hit a home run if you're afraid to strike out. And so as a prosecutor, you have to deal with double jeopardy. We had a viable reason for putting in this evidence, and so we did so. Ultimately, the court, as the AG said, ruled on Becky Hill. And then they said, while we're at it, hey, this is permissible evidence, but let's put some guardrails in place. That's just part of the process. They also, though, multiple times in the order talked about I think they called superbly competent and professional presentation by both the state and the defense. So these things are not 2 + 2 = 4, and we did our job. We still believe that the case should have been affirmed, but we recognize the court's reversal, and now we're going to go do it again. That's the plan.
Meanwhile, the defense team also releasing a statement. Dick Harpootlian and Jim Griffin, they were the primary attorneys in the original trial. Harpootlian says the Supreme Court's decision affirms that the rule of law remains strong in South Carolina, saying the court found that Becky Hill's conduct during the trial attacked Alex-Murdaugh's credibility and his defense. The court rightly described her, they say, as breathtaking, disgraceful, and unprecedented in South Carolina. Well, now that the court has granted Murdaugh a new trial, this case doesn't start over immediately. The case would likely return to Colleton County unless a judge approves a change of venue. Legal experts say a retrial would be a full reset here, meaning both sides could present new evidence, call different witnesses, and change their strategy. But one of the biggest challenges is finding an impartial jury in a case that's been followed nationwide. And there is plenty of reaction to the High Court's decision, especially in Walterboro, where the trial took place. Here's News 19's Kiki Gushu.
I'm here in front of the Colleton County Courthouse, which was home to Alex-Murdaugh's first murder trial. They spent 6 weeks inside this courthouse deliberating over his verdict. That verdict has now been overturned by the South Carolina Supreme Court. Alex granted a retrial. Now, residents in Walterboro say they have concerns about this retrial, questioning the fairness and whether it will bring the media frenzy back into their small town. For many people in Colleton County, the Murdaugh trial was more than just a national headline. It became part of daily life in Walterboro as media trucks, visitors, and crowds filled the small South Carolina town during the 2023 murder trial.
We've lived here during the trial and actually not far from the courthouse. So it was funny to see the excitement downtown and how Walterboro itself wanted to show the world what Walterboro had to offer.
Now that case is headed back to court. The South Carolina Supreme Court overturning Alex-Murdaugh's murder convictions, ruling former Colleton County Clerk of Court Rebecca Hill improperly influenced jurors during the trial. The court writing that Hill, quote, placed her fingers on the scales of justice, unquote, and denied Murdaugh his right to a fair trial.
Kind of knew it was coming, you know. South Carolina is known for lineage, legacy. Those kind of go first, then they work with everybody else.
The case has sparked broader conversations about power and influence in South Carolina's justice system.
Murdaugh's got a family name that, it travels around the state, not just in the area where he's practicing law or where he grew up.
Others, like Samantha Sylvia, say they understand the court's decision, but hope the retrial still centers around the victims.
But I also believe that when we're thinking about fairness and justice, we can't ignore the fairness and justice for those that were injured and the victims in the case.
Her biggest concern is making sure the new trial is fair and free of favoritism.
There is no favoritism. You want to see that somebody is treated like anybody else would, regardless of class or stature or any connections that they might have.
The original trial also brought new attention to Walterboro, with local leaders saying many visitors still come to see the town years after.
Walterboro has grown tremendously since the trial. We have a lot more visitors since people, it kind of put our name on the map.
Murdaugh remains in prison on separate financial crimes convictions as the state now prepares for a new murder trial. Community members we spoke to here in Walterboro also brought up another concern, using taxpayer dollars to pay for another trial when Alex Murdaugh is already in prison on financial crimes for the foreseeable future. They say they'll be waiting eagerly to see where this retrial will take place. In Colleton County, Kiki Gashu, News 19, WLTX.
Well, during the original murder trial, we provided daily coverage from the courthouse, and one of the reporters who was there, who spent a lot of time there, was Sam Perez, who is currently working for our sister station in Knoxville, WBIR. We spoke with her earlier today as she remembered covering that original trial.
Second time is truly shocking. The amount of resources, the amount of time that went into this, the amount of attention that it got from people all over the world, thinking of it now all again being repeated, again, just really is pretty mind-blowing. There were so many witnesses in this case, and for a lot of these people, it was, people, their neighbors they had interacted with. And so I think this town, for them to see so much excitement and chaos was overwhelming. That was what I was hearing from people when I was there. It feels like we know the strategy now. I mean, we know what the prosecution is going to argue. We know what the defense is going to argue. And so that element of surprise that you had the first time is not there anymore. And also, I've been, listening and watching to the analysis of what's going to be different and thinking about the fact that the financial crimes won't be able to be as big of a part of this new trial is really interesting, because I think that the prosecution spent a lot of time talking about those financial crimes, trying to use that to talk about Alex's character. And so the fact that they might not be able to do that to the same scope, I think will make a difference. And I'm curious to see how that plays out.
Again, former News 19 reporter Sam Perez. We're also getting reaction from the streets of downtown Columbia. Here's News 19's Megan Dalkshius.
Today, people told me they were surprised when they heard the news of a retrial for Alex Murdaugh. A lot of them found out for the first time when I spoke to them. This was their thoughts when they heard the decision.
I think it needs to be done. Justice wasn't there, carried out like it should have been. If we didn't get it right the first time, let's get it right the second time. It's going to cost money. I understand that. Lives are, at stake here.
I was shocked to hear it because I think the whole situation was premeditated, and I think that they went through the trial, they had all the evidence that they needed to convict him, and I think that it should be enough.
The evidence is stacked against him, there's no doubt about that, but what we practice here is fair trials, and any little glimmer of unfairness needs to be revisited.
Kind of shocking, but I think he's going to be in jail a long time regardless of this retrial, so hopefully this next time around he has a fair trial and no one tampers with the jury.
Well, I just feel that this is going to set a precedent that more people will have opportunities to get fair trials.
University of South Carolina professor of law Colin Miller says some people might be confused about just what the Supreme Court decided.
I think the biggest misconception is that the reversal was in any way based upon the evidence presented at trial, or that the verdict is in any way saying that Alex Murdaugh is innocent. This is saying the integrity of the justice system is compromised based upon the jurors being tainted based upon comments by the clerk of court.
Miller explains what it will be like going into a new trial.
So now both sides have some pre-existing knowledge of the evidence and the witnesses and the strategy. And it's kind of a chess game of how do we both readjust and recalibrate for trial 2, having already gone through trial 1.
This trial has gained national attention, and Miller says he doubts they will find jurors who have not heard anything about this case.
What the U.S. Supreme Court has said is you don't need that. Typically, if jurors come in and they're able to tell the judge, Your Honor, I've heard some things about this case, but I'm willing to set that aside and decide the case solely upon what's presented in the courtroom. Typically, the judge takes the jurors at their word, and that's likely what will happen here. I could also see the defense moving to transfer this trial to another place in South Carolina, and that might be successful.
Miller says it's unknown where the trial will be moved to, if it does move, and when the trial may start. In our conversation today, he did bring up that it's going to bring back emotional and mental distress for those involved, affecting those who are going to have to testify again, speaking of their loved ones. Reporting here in Columbia, Megan Dalkshius, News 19, WLTX.
And we want to bring in criminal defense attorneys Luke and Brian Sheely tonight to talk about today's decision. I know, guys, you're really not surprised we're getting a new trial. Brian, you thought the Supreme Court would come out with a decision about 3 months after they heard the case, and it was 3 months.
Well, I can't predict the future on everything, but I certainly got it right on that. And I think given the actions of Becky Hill, most criminal defense lawyers at least, believed was very likely to come back. And that, of course, is going to be a whole new, fresh start for both sides to get the jury trial going again.
Your reaction, Luke?
It was all about Becky Hill. It was just too egregious, too terrible. If you gave a pass to this situation and said that was harmless or somehow okay, then you'd be sending a terrible message to every South Carolina courtroom. So you just can't have it. I'm sure the state is very upset about it because it's just a completely unforced error by Becky Hill. The defense is very excited to get another bite of the apple, so it's a redo for Mr. Murdaugh.
I know when we were first talking about this, about the grounds possibly for a new trial for Alex Murdaugh, a lot of focus was put on the financial crimes being entered into evidence. But the Supreme Court in their decision, in their 5-0 decision, they didn't focus so much on the financial crimes as they did the Becky Hill issue. Right?
Right. I mean, they focused on Becky Hill, and that was all they really needed. I mean, they reversed and remanded based on that. If it would have been a lot closer call if we had no Becky Hill and we had the financial crimes only, it probably would have been a pretty close call. But they stuck with their guns, what everyone thought. They had the courage of their convictions and what we all hope. The sanctity of the jury room is kind of allowed to be intact again, which is wonderful for the justice system. And then they kind of sidestepped the financial crime aspect because they didn't have to really rule on that, but they did give some guidelines for the future trial court. And I think the prosecution team, at least, were referencing that today as they were going to take that to heart.
That's pretty important, though, because they didn't have to. They could have just left it. Like they didn't touch so many other issues, but I think they definitely sent a message about how it was clear that they kind of overstepped on the financial crimes without it being the deciding thing in this opinion.
So a new trial, when it happens, they can talk about the financial crimes, but according to the state Supreme Court, maybe not as much. They kind of went overboard. Is that right?
That's the gist of it. I mean, whoever is appointed as a trial judge will have to take this up freshly, but they will see that the Supreme Court says it went too far. It did cause prejudice. The Supreme Court is saying, we're not saying you can't get into it, but if you do, it needs to be short and sweet and not laborious about, how he mistreats vulnerable adults and really get into what we as lawyers call bad character evidence.
Let's talk about a new trial now. Earlier today, the state attorney general, along with the lead prosecutor, Creighton Waters, they were saying they hope to bring this back to trial before the end of the calendar year. And I know you guys think that's probably a little too much right now, right? To do it before the end of the year?
I think that's correct. First, we got to get a judge assigned, and then that judge will, probably want to figure out scheduling from both parties. It's not just getting their calendars together, JR. It really, truly is, because it's a fresh start. So the state could choose to, not, belabor all the financial crimes issue. A trial judge may be interested, in scheduling, is it going to be 6 weeks again? Is it going to be 2 or 3 weeks, just focusing on the murders? So, but then once you get that going, you have to also figure out where you're going to try the thing, because, I know, Alex Murdaugh's defense team would be very interested in getting it out of Colleton County due to the notoriety certainly there with his family, also the Becky Hill connection. And so I think there'll be a lot of heavy litigation regarding where is this case going to be tried, what's the venue going to be, and then once that gets set, it's a lot of infrastructure, right? Like that trial, some people called it a circus, some people called it the trial of the century in South Carolina. Maybe it was a combination, but it took a lot of manpower, a lot of scheduling. So I think Alan Wilson wants to be responsive. I think his team with Creighton Waters wants to be ready. The state's always ready, and the defense is always prepared, or is it the other way around? That's just an old saying, but they want to be able to proactively get this on a trial docket. But I think there's caution that is necessary to make sure both sides are ready, get the venue figured out, and then I know JR, Luke, and I mentioned earlier that because of the international microscope on this case, it's probably going to take some more advanced jury selection than what is normally allowed in criminal defense trials. Normally, unless it's a death penalty trial, normally there's just standard judge-issued questions. I think we both agree that in this case, it would be prudent to have kind of exhaustive, enhanced voir dire, attorney-conducted questions to the jury to really flesh out their biases or potential prejudices due to the fame of this case.
In his news conference today, the state attorney general did say they want to take the case back to Colleton County. Look, I know you're with your brother on this and saying it probably won't be tried there, right?
I don't think it will. I can see why the state would like that, because it's so saturated, and probably any person you bump into there on any corner would be like, Murdaugh's guilty, he's a terrible guy, he embarrassed all of us. So that's exactly why it can't go back there. I mean, changing venue is not necessarily easy. It's the burden rests on the defense, so they're going to have to make a showing that they can't get a fair trial. I'm sure they'll be working on that and pulling data and doing some polling and showing the news articles. I don't think it'll be there. I think a judge will say, all right, fine. I don't want this to be a legal issue embedded in this case. Can we agree on a county? And if not, they'll think of some other ways to get there. But it will not be in Colleton County.
Other than focusing so heavily on the financial crimes, what can be done different with the prosecution and the defense in this case once it goes to court again?
Well, I think from a defense perspective, and we touched on this earlier, you got to think, do we put up our client or not? And that's a big strategy decision. So to a certain extent, as a defense lawyer, you want to be prepared for everything. And even if you're not sure until maybe the day of the trial when your client would testify, it's ultimately his decision. So you kind of prepare for everything, but you're also pivoting with the thrust of the state's prosecution theory. And so they have a very circumstantial evidence case. And so I don't think any of that's going to change in terms of the circumstantial nature of it. They did get kind of a very polite smackdown from the Supremes about don't necessarily, we're not saying you can't do it, but just don't drag in all this financial stuff, or there could be problems. And so I think a lot of it will be dependent upon how the state pursues it, but the defense could do a lot. They could do, they put up Alex Murdaugh again and explain the circumstances of some of his maybe untruths in his testimony, or they could not put him up and then just poke holes in the circumstantial case, which is a very common way to defend against a circumstantial only kind of case. It'll be fascinating.
And for those of you at home who do not know, there was no DNA evidence, there was no blood evidence, there was no murder weapon, so hence the circumstantial evidence in this case. If you are the defense, do you put Alex Murdaugh back on the stand?
So it's a tough call. Ultimately, it's his decision. We all, probably most folks would think he did not do amazingly well the last time, but he was forced to spend most of his time admitting that he was a liar and a cheat and a thief to people that he had a duty to protect, his clients. So if you take all of that out of it, and if he were just to answer questions about the murder case, I don't know. He would need a lot of work. It would take a lot of analysis. But like I've said before, it's the client's call, and the client has to trust the lawyer. And if the lawyer says, I don't think this is a good idea, the client can still say, hey, my case, I'm testifying.
How do you redo that key piece of evidence, that piece of video that was on Paul Murdaugh's phone down at the dog kennels where you heard Alex Murdaugh speaking just moments before the murders were committed? How do you undo that if you're the defense? You can't very well go in there with a new jury in a new place possibly and say, yeah, my client was down there all along, and he said that all along, because that's not what he said originally in his first trial. It was only when he was confronted with the tape that he admitted to lying, right?
That's a really big consideration for his testimony. So if he and the defense team choose at the future trial not to put him up, it very likely could be for that reason right there. So then you don't get to cross-examine him and impeach him on his prior sworn testimony that turned out to be not to be the truth. And my recollection of that is he tried to backtrack and explain it. And, oh, well, I meant, but the state pounced on that, and we were able to really seize in the moment and say, well, you're a liar, so what are we supposed to believe now? So yeah, that'll be a real consideration. So it's a lot of tactical strategy, a lot of real trial strategy and nuance that we will have to see what's going to happen on it.
We saw the last trial unfold minute by minute because cameras were in the courtroom. Can the defense, or could the state of South Carolina make a request this time around, the second trial, no live broadcast, no cameras in the courtroom?
They can make the request. I doubt it will be granted. I mean, the media has very powerful First Amendment rights to be present and record and document things that are of public interest. So there's some pretty smart lawyers out there for media companies as well that can cite those cases. So I don't see any way that the media would be out of the courtroom. The only real concern there is that you have a jury member who's seen what happened with the past analysis of the jurors, the tampering, the egg lady, and all the names, that they don't want to be on this jury. They don't want that scrutiny. They don't want anybody to find out who they are. So that's the real concern, but you're just going to have to really take precautions to make sure that their identities are protected and that they can deliberate and do their jobs privately. But the media will definitely be there.
Speaking of the media, again, we did broadcast the trial in its entirety, not only here in the Midlands, but viewers from around the world. A fascination with this case. The murder is happening about almost 5 years ago now, but there's still a lot of public interest in this case. Why is that?
It is Alex Murdaugh's background. He comes from a legal, dynasty, so to speak. Lots of, and not just any dynasty, but a low country dynasty with lots of prosecutors in his family, generations of well thought of lawyers, prosecutors in the community, and then these murders, and then the theft associated with half of the charges. It is.
People love a spectacular fall from grace.
Fall from grace. That's what I'm looking for. A real fall from grace. And so, and there's a lot of intrigue around it. He didn't confess to it. They didn't find a bloody, article of clothing or a weapon that, fit the shell casings. I mean, there's a lot of mystery to this. It was never going to be an open and shut case for the state. And so that also lended some intrigue to it. It was not an easy case for the state to prosecute successfully. So all of the above, and here we are for round two.
He was convicted of some financial crimes. He got 40 years in prison for stealing some $12 million. That is a separate conviction, a separate sentence. I know we had a lot of viewers today asking us, is he going to get out on bail? Is he going to be out of jail awaiting a new trial on the murder convictions? But that's a big no, correct?
100% no. He's serving his federal sentence concurrent to the state sentence. I mean, he's a man that's in his 60s, and he's got, 27 years on one, 40 on the other. So he's not going anywhere. But from our understanding, it's really just not wanting the legacy of being a family killer, a killer of his wife and child. So, but he's definitely not going anywhere. It's not like he's going to, be seeking a bond or anything like that. That will not happen in this case.
Is there a possibility he could be offered a plea deal in this case to plead guilty to something lesser than murder?
That happens a good bit in what I would call a normal case, even a normal murder case, where if it comes back on appeal for whatever reason, evidence gets stale, investigators retire, witnesses die, things like that. But here there's just so much embarrassment as a lawyer representing South Carolina, and there's so much scrutiny that I think a plea deal is not going to happen, because the state of South Carolina would look weak. They would look like they're, giving some kind of helping hand to a guy that they prosecuted vigorously for 6 weeks. So I don't see it happening. I also don't see him taking really any kind of compromise based on what I could tell of his own personal moral compass on the way he viewed this case and his adamant denials. So it's not happening.
Well, he's not getting out of jail on the financial crimes conviction. So some of our viewers are asking tonight, why even have a new trial to begin with, since he's not going to get out of prison?
Because he's presumed innocent, and the murder case was overturned, and it's got to either be prosecuted or dismissed, or he takes a plea deal.
So the plea and the dismissal are not happening.
Right. So we move forward. So it's not like the state could just, they've got victims, right? There's victims' rights. So let's say there was not the political energy to prosecute this case. It was a different case, not the most famous case in the state. They would still have to consider victims' family members' wishes. And even on a normal type murder case, that can be a lot, even if he had already secured another long sentence like Mr. Murdaugh has done in this case. So it's not really something that the state can just say, we're going to drop it because we already got his time in a different way, and he's presumed innocent, and he's got a right to his day in court. So it's going to be a trial.
All right. Brian, Luke, Sheely, guys, as always, thank you so very much for your time. And thank you for watching. Of course, we have much more on the Supreme Court decision, plus more reaction, more details. You can find it on our website. That's WLTX.com.